Welcome to JMW's Inside Man YouTube channel. My colleague Nelly Borisova is an associate within JMW's property litigation. So Nelly, you've recently written a blog about whether a deposit should be returned by cheque or not. I suppose the obvious question is, what's the answer about the cheque?
Well, it's a simple question, but it doesn't really have a simple answer. The simple answer is yes, it can. But if you ask me whether landlords should do that, then I would say no. And that's when it gets interesting. And my blog post talks about a recent case where a judge considers whether a deposit was returned validly. And this case actually found against the landlord.
And so why do landlords need to know about this, Nelly?
The importance here is that whether a deposit has been returned validly or not could affect the validity of a Section 21 notice, which is a possession notice. So landlords are required to protect a tenancy deposit, and they are required to comply with certain rules about how to do it and what information to provide to the tenant. And if they are not certain whether they have complied with their obligations properly, if there is any sort of dispute about it, the safest way to make sure that you can serve a valid possession notice is to just return the deposit before you serve your notice. So that's usually when you're talking about there has been a breakdown of communication or the relationship between the landlord and the tenant, when the landlord usually decides the safest way is to just send or drop off a cheque back at the property, returning the deposit, and then they consider it returned and they can serve their notice. However, why this is a problem and why this is something that the court had to consider is it's never really been clear whether that's a valid way to do it, especially when, for example, the tenant hasn't actually cashed the cheque. The tenant says that they never got the cheque, or where everything else has happened by way of bank transfer. So is it acceptable for then the deposit to be returned by cheque? So these are all of the questions where the law is unclear. And there was recently a case in the County Court of Central London, and finally there has been some guidance. So there isn't still a clear answer, but the judge has set out what factors will be considered when deciding whether the return has been valid. So landlords are best advised not to rely on a cheque unless they have agreed that specifically with the tenant that the tenant will accept it, or unless there is a clause in the tenancy agreement which provides that that will be valid. Without that express agreement, it will basically depend on the facts of the case. Did the tenant refuse to accept a return by cheque? So did they contact the landlord and say, I'm not accepting this as valid return of my deposit? Did they just say nothing? And how long has it been since the cheque was posted to the tenant? So as I mentioned, in this case, the judge found that the cheque had not been a valid return of the deposit, and that was because what the landlord did is drop off the deposit, the cheque, at the tenant's property a few days before serving the notice, and in between returning the deposit, dropping off the cheque and serving the notice, there were only a few days, and including a bank holiday. So the judge found that it was not reasonable for the landlord to assume that that's valid return, especially where there was no confirmation from the bank that the cheque has been cashed. However, this same judge, we've acted on a case where the judge had to consider this same issue, and actually in those circumstances, the judge found against the tenant, and he found that it wasn't reasonable for the tenant to not have banked the cheque, but a lot longer had passed in terms of time between the dropping off of the cheque and service of the notice. So it very much depends on the facts.
And it sounds like a minefield, even with this case, Nelly. How can you and the property litigation team help? Well, both landlords and tenants. I know you act for both.
Yeah, so it's very important. I mean, we always say it's very important to get adequate legal advice to begin with, and especially in cases like this, it is, because otherwise you're running the risk of serving a notice, going down all the way the possession route, going to court to a trial, and then only finding out right at the last moment that your whole case is collapsing because your deposit wasn't returned validly and the notice you've served is defective. So there are a couple of ways to address an issue where someone needs help, whether it's a tenant or a landlord, is to look at your tenancy agreement or to make sure you have an adequate tenancy agreement in place that deals with what's an acceptable method of returning the deposit. And the other one is before you, if you are a landlord, before you serve your notice, before you issue your proceedings, taking advice to make sure you're aware of the risks and you can take a commercial view and a commercial decision. And at the same time, if you are a tenant and you are on the receiving end of a possession notice or a deposit again, and you're not sure and your tenancy agreement does not deal with this, contact our team at JMW. We are experienced in property litigation and we'll be able to advise you on whether the notice served on you is valid or not.
Nelly, thank you for your insight. If you'd like to speak to Nelly and the property litigation team here at JMW Solicitors, you can email insideman@jmw.co.uk or call 0161 82 81 999. Please also subscribe to the JMW Inside Man YouTube channel for the latest legal news, hints and tips. I'm Dominic Walker, JMW's Inside Man.